Yes, Ms Jones.
Good morning, Sir Brian. Good morning, everyone. As I explained yesterday, I will now go through the last part of our submissions. This section will focus on redress. I will then close our submissions with our clients' voices. Before I turn to that, sir, there are just two matters for me to address. The first relates to a mistake I made during my part of yesterday's submissions, for which I apologise. When I was discussing the exchange between counsel and Professor Hopkins, I said that Mr Hill was counsel, when in actual fact it was Miss Richards. So my apologies to you, sir, and Miss Richards. And the second point, sir, is to confirm our position on parliamentary privilege. In respect of the issues relating to parliamentary privilege, we broadly agree with the submissions of counsel to the inquiry that there are factors that point in both directions. We are aware that the Speaker's Council takes a robust and expansive view of the scope of Article 9. Without wishing to duck the issue, we would suggest that it would be more than possible, if you wish to do so, to address the issues raised in written submissions and the concerns expressed without impinging upon parliamentary privilege. But, sir, that's all we've got to say on that matter. If you want us to expand any further, we'll, of course, do so in written submissions.
No, I don't think that will be necessary. I think it's unlikely that I will have to actively resolve the issue in this particular inquiry, although I have perhaps some views to express. But I shall think about that.
Thank you, sir. Turning now to redress, and to begin with looking at financial redress. Our core participants, when they asked for redress, were given either nothing or ex gratia payments which were too little and too late. I intend to focus this morning on future arrangements which should be made for financial compensation, but I wish to open my remarks regarding the trusts and schemes by recognising the cruel, humiliating and insulting way which the ex gratia payments have been made to infected and affected individuals to date. There can be few such striking examples of adding insult to injury than causing deaths and debilitating illnesses and then forcing victims to beg for scraps from the table. Almost all of those who we represent have stories of such treatment. Many were refused compensation because of the negligence of the health service in failing to record their treatment or losing their records. Others were stigmatised and disbelieved, being treated as though they were con artists who had picked up diseases as a result of their own choices. Our clients have been excluded from the schemes because of blood received after the cut-off date of September 21, even though no one can explain why that cut-off date was chosen, and they have been excluded because the infection they contracted didn't have the right name. It was HBV rather than HCV or HIV. If the government wished to create a scheme which looked as though they were helping out while paying out as little money as possible, then they achieved their goal. This begrudging, destitution-level support, which has also understandably damaged the faith that our core participants have in the government's commitment to providing any compensation scheme. And so it is against that backdrop that the future compensation scheme must be developed. It must address and avoid the failures of previous schemes, and it must provide generous and prompt compensation to those affected by this tragedy. And we use the word compensation deliberately, sir, because there has been serious wrongdoing here. In relation to the recommendations that we set out in our written submissions, I would like first to turn to who should be eligible for compensation. Like other core participants, we largely welcome Sir Robert's recommendations. However, there are a few areas in which we would urge you, sir, to go further. In particular, the inclusion of HBV within any compensation scheme, the removal of the cut-off date of September 91, as well as the inclusion of natural clearers. It is of the utmost importance for our core participants that financial compensation is prompt, generous and secure. The financial support they receive must continue for the rest of their lives, and we endorse Sir Robert's suggestion that this should be formally guaranteed by the government. This must also be reflected in the structure of the future scheme. It must have open-ended funding that can meet the needs of all applicants rather than being ring-fenced. The £100,000 interim payment already paid to some should be extended to those not eligible under the current schemes. Those who, for instance, are excluded by virtue of the cut-off date or infection with HBV should immediately receive an interim payment. The estates of those where there is no bereaved partner should receive the £100,000. Further, we strongly endorse Mr. Snowdon KC's suggestion that this inquiry should call for further interim payments to be made, given the length of time the creation of any new scheme is likely to take. The future compensation scheme must be created with the infected and affected community. Redress must be made with them rather than doled out to them without their involvement. As we have seen through this inquiry, the infected and affected community know their needs best and are best able to identify and advocate for change. While we broadly endorse Sir Robert's suggestion of a tariff-based scheme, we emphasise that this must incorporate proper individual assessment, especially of past and future special damages. The assessment should be holistic. Tariffs should be developed in consultation with the infected and affected community, who must have a meaningful opportunity to contribute.
Just pausing there for a moment. Many of those who are listening will understand the expression special damages. Certainly the lawyers will, but in case there are some who don't, by special damages you mean actual financial losses, in contrast with general damages, which is a sum to be assessed to compensate for what, in one sense, can't be compensated for at all, the injury, the loss, the suffering, which somebody has endured.
Yes, sir.
Is that broadly right?
That is broadly right, actual financial loss. But so also if, for example, an infected person has received care from their loved one or a family member, then that is known as gratuitous care, and the costs of gratuitous care should also be included within.
Well, it's capable of assessment in financial terms, although I'd be interested if you want to make submissions now, or for that matter later, as to what you say this inquiry should recommend, bearing in mind is not itself dealing with court compensation, with the principle which would apply if it were a court, which is that the loss suffered by a carer is not the loss of the carer, but it's the loss of the person who requires care. Hence, it gets added to the infected or the suffering person's, the victim's award, and he then gets it subject to a duty to pay over to the individual carer, where it might be thought more simple and more appropriate for the carer to be compensated not as the individual's loss, but as their own loss.
I agree, sir. And if you decide to offer ideas in relation to a future compensation scheme, then we would support the idea that an affected applicant who has provided the care should be entitled to receive financial it wouldn't be compensation, should financial support for the care that they have provided, rather than, as you say, the money's being paid to the infected individual who then has to pay it out.
And in particular, what I have in mind is that the calculation may not be an easy one, but there must be a large number of carers, people who have been affected persons, as we've described them, who have sacrificed their own careers, their own earning opportunities in order to provide the care in the very special circumstances where, because of stigma, no one else could.
And that's right, sir. And you might choose to go further than the current law of tort that I believe suggests that a person that doesn't work but provides care can receive payment for the time and the costs of the gratuitous care, but cannot recover loss of earnings. So you might feel that actually assessing an affected individual's loss of earnings might be a more appropriate way for the scheme to operate.
Well, there are the actual financial costs of providing care, which the individual who provides the care will suffer, but there are also physical, psychological costs too, which must be borne in mind, plus the ever-present risk of cross-infection.
Yes, sir. And I would hope that the compensation scheme that would apply for affected applicants would include general damages for those types of injuries, the psychological impact and the stigma, as you suggest, sir. And I believe in Sir Robert Francis's report, he does set out tariffs for stigma and the social impact of somebody who is infected and affected. If that is wrong, sir, I apologise, and I can check that in the break.
Well, if one were looking at this as a court case as well, any person who is a secondary victim of an accident or incident would only be compensated if they came within a particular class of those who are the classic way of describing it is nearness, here-ness and dearness within that category. Is it really appropriate in these circumstances to look at that in any other way than a broad brush way in assuming that anyone who does care is within that sort of class?
I agree, sir. I think the current position or the current state of the law in respect of secondary victims, so they're people who haven't suffered the injury themselves, but are, as Sir Brian said, nearest, dearest and...
Nearness, dearness and here-ness of an accident. The classic case is someone whose toddler goes round the corner on his pedal bike, there's a sound of a crash, and they arrive and they don't see the accident, but they see its aftermath. And they may well suffer shock. It used to be called psychological shock from witnessing or being within that general area. And there have been lots of arguments about how far it extends and whether it extends to the person who suffers the corrosive impact of being an ever-present at the hospital bed of someone who's dying.
I believe, sir, the Supreme Court is going to be exercising itself in a case, hopefully in the not too distant future, about those control mechanisms.
Is this one of yours?
No, we've got one stayed behind it, so fingers crossed. But so I think if you were able to recommend a scheme that didn't impose such narrow restrictions, it would make it far simpler for applicants and also for any awarding body to be able to consider the issues and to reach the right level of compensation?
Well, at the moment, the way that I tend to regard the principle is it's one of public policy preventing unlimited liability to an unlimited class for an unlimited length of time. If that's wrong and is not an act of public policy, then I would welcome hearing from any of the lawyers that that's the case. But I'm not engaged in a court case assessing compensation. I'm here dealing with what is appropriate recompense, assuming that I recommend it, appropriate recompense for those who have suffered. They're very different, but in their very particular way.
Yes, sir. I don't have anything to address you on, sir, further about the matter of public policy. Don't know if there's anyone else.
It's a matter of
Yes.
people can take their time and think about it, and if they disagree, please let me know.
I do not disagree. I think that the proposal that you have set out would be the fairest and simplest way forward for everyone that's been infected and affected by this tragedy.
Thank you.
We consider that the awarding body for the new compensation scheme should be an independent, arm's-length body with rights of appeal. A body that understands the background of the infected blood scandal and which seeks to be inclusive rather than exclusive. There should be a reversal of the burden of proof, or at the very least, a lower standard should be applied, by which I mean a reasonable degree of likelihood rather than blood having been received on the balance of probabilities. And there must be no insistence upon medical records as a precondition for eligibility. Our core participants also require meaningful support and non-financial support, which should not be overlooked or deprioritised in the process of creating a new compensation scheme. The awarding body should be aware of applicants' social needs and should be properly equipped to support applicants to assess comprehensive welfare services, including housing, income support, and social care. We invite the inquiry to recommend that the UK adopt a model of free services such as that described by Brian O'Mahony in his evidence to the inquiry. That includes free dentistry and optometry services, free hearing tests and hearing aids, free physiotherapy, free complementary therapies including massage, reflexology, acupuncture and any other appropriate services, a government guarantee to insurers which will allow the infected and affected individuals to access life, mortgage and travel insurance on a level playing field with other customers. Many of our core participants have very substantial needs for care and support. We invite the inquiry to recommend that infected individuals are provided with free domiciliary support and social care services as needed. Once again, applications for such support must be viewed sympathetically and on their own merits. And in order to access these services, sir, we urge the inquiry to consider recommending the introduction of a role such as the liaison officer in Ireland, which Mr. O'Mahony referred to as crucial. So this is our last chance to make meaningful redress to the victims of the greatest disaster in NHS history. Now is the time, at long last, to compensate and support the people who have been rebuffed, excluded, and dismissed for decades. The government response must be swift, generous, and unstinting. The government's position and failure to issue a response to the Paymaster General, at the very least, threatens a potentially long and drawn-out period, whilst any recommendations that you make, Sir Brian, are implemented, if in fact the government chooses to implement them. Sir Brian, we urge you to make a further interim recommendation that the government makes further interim payments to those infected and affected, including those who were excluded from the last interim payments. There is a very real and palpable fear that it could be years before the government finally has a scheme in place. Our core participants fear that this process is being deliberately drawn out to minimise the compensation to be paid, and that they will be dead before any money is received. We would also urge you to recommend that the government implementation of your recommendations be scrutinised and reviewed either by this inquiry or by an independent body which includes members of the infected and affected community. You will be aware, sir, that the Hillsborough disaster has been in the news again over the past few days because of the waiting of the official report, because of the anticipated official police response to the report of the Right Reverend James Jones. His report, The Patronising Disposition of Unaccountable Power, was a review of the experiences of families affected by Hillsborough and was published in November 2017. It set out 25 points of learning relating to the response of public bodies to state-related deaths. We're now 5 years on, and over 5 years there has been no formal response from the government, which the Reverend described as intolerable for the families. When asked for comment, the Home Office said that it was committed to responding to the report as soon as practicable. And this is 5 years on. We would ask you, sir, to urge the government not to delay in responding to any recommendations that you might choose to make. The infected and affected to this inquiry have waited decades for redress, and tragically many have died without it. They cannot and should not have to wait any longer. So another feature of redress is, of course, a meaningful apology. Our clients have waited too long for a recognition of the immense harm and suffering they have experienced. Many have died waiting for an apology. Now is the time for a step change from the state and other agencies that have played a role in this tragedy. In our written submissions, we invited apologies not only from government, including the DHSC, but also the UKHCDO, the Haemophilia Society, and the pharmaceutical companies. So you'll recall when we were speaking about discrimination yesterday, I said that I would come back to issues in relation to racial discrimination. And here, so I'd like to address you in relation to particular redress and action for minoritised ethnic communities affected by infected blood. So we have a number of core participants who were infected via their treatment for blood disorders. These conditions are likely to require frequent transfusions with blood components of various kinds. Given the significant number of individuals in the UK with sickle cell anemia, or thalassemia, it is likely that a number of these patients would have been infected with HCV and HIV. The statistics expert group was unable to break down the medical reasons for blood transfusions in those who were infected with HCV or HIV, other than to identify that more women than men, aged between 20 and 50, required transfusion, and that was probably because of the use of the treatment, by which I mean blood transfusion, during maternity care. In response to a comment put to Professor Dame Sally Davis by CTI that blood-borne viruses were not really on the radar for this group of patients, by which I mean patients with bleeding disorders, she referred to the context of health inequalities suffered by her group of patients and the patchy services they received. We submit that the fact that this condition is disproportionately suffered by those from a sub-Saharan, African or Afro-Caribbean ethnic heritage contributed to and compounded these inequalities, and therefore contributed to the lack of spotlight or understanding of the secondary issue of blood-borne viruses, which statistically, we submit, it can be inferred would have affected this group disproportionately. Professor Davis indicated that during her time at the Middlesex Hospital, there was less research being undertaken into sickle cell anemia than other forms of blood cancers or disorders, and she expressed her concern that this may well have been what she termed as institutional racism. She also identified that the funding for sickle cell patients may have been influenced by their ethnic background, saying, "I feared it might be, because if you look at the money spent on haemophilia patients and the numbers, the discrepancy was unfair. I was concerned about the fairness of it," and so we can get the reference for that transcript for you in the break. The fact that clinicians such as Professor Dame Sally Davis were focusing on the priority of getting decent services in place and as a starting base for these patients meant that the issue of blood-borne viruses was overlooked. So we consider that a similar inference can be drawn for patients with thalassemia, who are disproportionately people of Mediterranean, South Asian, Southeast Asian and Middle Eastern origin. So we invite the inquiry to conclude that, much like our female core participant cohort, existing health inequalities, and in this case arising from ethnic and socio-cultural determinants of health, intersected with the general failings outlined above, leading to disproportionately worse outcomes for core participants with blood disorders. The inquiry has also examined the stigma and shame that can be associated with HIV, HCV or HBV, and that there can be a double stigma in some communities. You heard powerful evidence of the fact that some choose to hide their diagnosis for fear of being ostracised by their communities. We would ask so that the inquiry recognises this. As we have identified, we consider that this inquiry is in a position to make recommendations concerning health inequalities in the context of the evidence that the inquiry has heard, which could make meaningful change for the future. So, as you know, there is now an Office for Health Improvement and Disparities. One of its roles is to gather expert evidence and research and to identify how to address the issues. We would ask that the inquiry identify to the Office for Health Improvement the information that the inquiry has uncovered that poor treatment and outcomes for conditions such as sickle cell and thalassemia may have masked issues around their infection with HIV or HCV or HBV. The government should recognise that those from minoritised backgrounds may well have had double discrimination. The Office for Health Disparities should be asked to examine this in respect of viral hepatitis and HIV and identify ways to improve their care and treatment. And so finally, the inquiry might wish to consider recommending that the government should consider initiating a widespread review and/or a public inquiry into health inequalities. And finally, turning to our core participants' voices. We must end these submissions by acknowledging the immense harm and suffering experienced by all of our core participants as a result of the infected blood scandal. Lives have been lost and lives have been shortened. Debilitating and extreme pain has been many of our core participants' daily experience. They have lost parents, children, siblings, and partners. Whatever the outcome of this inquiry, nothing can never make amends for such devastation. One example is the core participant we represent, who expressly held consent for her 5-year-old daughter to receive a blood transfusion where it was not medically necessary. The following day, her daughter's doctor transfused her without her mother's consent. When our core participant objected, the doctors laughed at her. Her daughter developed HCV, from which she died at the age of 16. That young woman would have been 36 years old today. Her mother has explained, there's not enough words to explain how someone feels when that happens to them. Many of our core participants describe the stigma of their infection, whether that be HIV, HCV, or HBV, being so acute that they felt dirty, ashamed, guilty, unclean, like a sewer rat, poisonous, and like a leper. Our core participants have been thrust into a position of living with the constant, unspoken fact of death hanging over them. One core participant quotes from their psychologist, who notes, X lives with the fact that hepatitis C is a life-threatening virus. The uncertainty that generates has a direct effect on his level of anxiety and depression. Also, each time X is made aware of someone who, having been well for a number of years, has suddenly become ill from the virus and died even, it is a powerful reminder of the reality of the threat under which he lives. Others describe how the only thing keeps them going in the face of the fear is not wanting to leave the planet without being sure that there will be adequate compensation for their families. The affected, as you rightly pointed out, sir, have suffered acute vicarious trauma, as one core participant described it. The most difficult thing is watching somebody you love fall apart day to day. I can only describe it as like watching an old car with bits falling off progressively. It's like there is a paleness or a greyness to every day, but you must try to keep your loved one cheerful and keep them going. All you can do if you feel overwhelmed is go out into the nearest field and shout. To close, Sir Brian, our clients have found the process of this inquiry cathartic, but the wrongs of the past 40 years have to be righted. There must be swift, meaningful, and comprehensive compensation and unconditional apologies. There needs to be wholesale and systemic change in the way that patients are cared for and the way that the NHS responds to its own failures. It must become compassionate and open. That would be the greatest and most important legacy of this inquiry and this whole tragic affair. I wish, as I finish these submissions, to remember the 11 of our core participants who have passed away during the course of this inquiry, and all those who are no longer with us. None of them will be forgotten. Each of the core participants we represent has a unique story which is uniquely tragic. As a team, we have been honoured to represent them. Further, the way in which all of those infected and affected have conducted themselves during this inquiry has been humbling. They have acted with dignity, showing respect for each other. They've acted with compassion and commitment. So they are not a group to be dismissed, disempowered and defended against. Instead, they are a group who deserve accountability, acknowledgement and action. And once again, I thank each of them for their courage and resilience in sharing their stories with us. So Brian, unless I can be of any further assistance, those are our submissions.
No, thank you very much indeed, Ms. Jones, for those submissions. And I shall consider them, of course, carefully.
Thank you, Sir Brian.
And thanks to Miss Morgan as well. Now we'll take a short break. There's no need to leave your seat unless you wish to, but by all means do if you want, for about 5 minutes before we'll hear Mr. Williams on behalf of the clients represented by Watkins and Gunn.